Carter Hart's lawyer started her closing argument. This is part 4 of my day 1 recap of the closing arguments in the 2018 Team Canada SA trial. Make sure you follow so you don't miss anything as the trial wraps up. The lawyer started off by suggesting that some of the Crown's witnesses actually ended up helping the defense's case. She said that Hart was excited not just because there was a woman doing these things, but because she wanted to be doing these things. She also said that as a reminder, Hart received oral for a very brief time. She said that when Hart asked for oral, she crawled over to him and got up on her knees, which signals consent. The lawyer then argued that Hart would have had to believe that McLeod would have received consent from EM before inviting the guys into the room. She said that when Hart responded, quote, "I'm into the, quote, three-way text," he wasn't saying he was in regardless of what was happening in the room. He went to the room to see what was happening, but then asked for a, quote, blowy, which is a form of, quote, boundary setting. Quote, asking specifically for oral sex is an effective and inoffensive way to communicate to your partner that you don't want vaginal sex that you've been offering. The lawyer then disputed the Crown's argument that when EM was offering vaginal sex but Hart asked for a, quote, blowy and then put his penis near her mouth means he didn't get consent. She then said that all the witnesses called by the Crown remember the same things, just not in the order or what time that they happened. They all remember the oral sex that Hart got because that was the first sex act of the night. Quote, it was memorable by its nature. Quote, participating in or watching your friend participate in a sexual act in this tight-knit group setting, right in the middle of a hotel room, right in front of you, and in response to a naked woman who is asking for it, is something that grabs the attention. The judge then interjected, saying that everyone who was in the room except EM says that she was, quote, asking for sex, and the lawyer agreed with that. The lawyer then also said that EM is the only person who said there were 3 men asking and getting oral at the same time, adding that everyone else only testified about oral sex one at a time. The lawyer then started talking about hockey stereotypes. She said that the trial has seen, quote, this insidious idea that hockey players, by the virtue of the fact that they play closely together on a team in professional sports, naturally protect their own, circle the wagon, so to speak. He then said that Hart's testimony was not always helpful to his co-accused. He tried to be, quote, responsible and helpful regardless of who was asking him questions. Quote, he didn't become a, quote, yes man for the defense. The lawyer argued that even if the judge doesn't believe Hart's own evidence, she must acquit him because of the evidence in the Crown's case. She said there's a 30-minute gap in EM's memory, and it's after that 30 minutes that Hart comes into the room. Quote, what we have in this case is a total absence of evidence about what happened before Mr. Hart came in. The lawyer then said, quote, we have a complainant who initially and repeatedly described the encounter as consensual, and apparently so. EM did not describe being frightened while speaking with the first detective, for example, adding that the woman also has very little memory of the night at all. The lawyer said, quote, my primary argument is that she was consenting enthusiastically and regretting it later. She said that was based on EM's own evidence, and that when her mind detached from her body, nothing traumatic had happened yet. The lawyer then said that victims of sexual assault react in all different kinds of ways, but that's not what happened in this case because the reaction that EM described happened before any of the additional sexual acts took place.